Hello. As you've heard, I'm Michael Mukasey, and I'm here with Gabe Schoenfeld, author of what I think by any measure is a superb and essential book these days, a book called Necessary Secrets. I think it's fair to say that this book contains a narrative that's very different from the one that we've heard up until now about the legality and advisability and historical basis for publishing national secrets in our daily newspapers. And I wondered if you could just summarize that point for us, Mr. Schoenfeld.
Well, there's a standard narrative which goes something like this, that the press is given the First Amendment. We have a First Amendment in place that allows the press to publish anything that it will in the realm of national security. I think that is historically a false narrative. If one looks back at the system that our founding fathers constructed, they were very concerned with the problems of secrecy. After all, they were drafting our fundamental documents in a period in which we were at war with the British. Military secrets, diplomatic secrets were things that they were very, very intent upon keeping secret and not obviously disclosing them to the enemies of the revolution. But it goes beyond that, because in the institutions they devised in the Constitution, they were also very intently interested in the way that information flowed or did not flow among the branches of government, so that Congress, for example, was given both houses was given the right to not publish their journals of their debates. They were in other words, they were enabled to have secret sessions. The president was not obligated, except on a time-to-time basis, to share information from the executive branch with Congress. So secrecy was really wrapped up in our basic institutions. And the idea that the press would be able to report on things that would compromise military security or diplomatic negotiations was really something that the founding fathers would have been shocked by and frowned upon. The question of what they would do about that is a complicated one when such instances occurred, and they did occur in those years. But they were rather different from some of the kinds of leaks that we've seen in recent years. They were tended to be diplomatic in nature rather than military.
And maybe we'll get into that a little bit later, but I wondered if you could tell us what it was that led you to write this book.
Well, it was several things. I was an editor then at Commentary magazine here in New York. I'd been here living in the city since the 90s, and of course I was here on September 11th, 2001. And I stayed in the city, and I was here on March 11th, 2004, the day that the Madrid subway system was attacked and killing hundreds and wounding many more. And I was here again on 7/7/2005 when the British transit system was attacked. And I ride the city subways daily. 2 of my 3 daughters do. Millions of New Yorkers do. And in December 2005, I was really I was shocked and curious after the New York Times published stories revealing some of the most basic, most critical counterterrorism secrets that the U.S. government had going. Programs that were designed to keep a repetition of September 11th, or to keep an attack from and to keep an attack like the subway system attacks that we saw in Spain and England from occurring here. And I began to ask the question: is it legal to publish such material? And that it turned out to be not a simple question to answer. That and I spent first I'd written an article in which I called upon the Bush administration to prosecute the Times under a statute that protects classified information pertaining to communications intelligence. And that led to invitation to testify before Congress, before the Senate Judiciary Committee and the House Intelligence Committee about these issues. And while all this was underway, the Times went ahead and published another, even more serious breach to my mind, revealing that the CIA and the Treasury were involved in a joint program to monitor al-Qaeda finances via a Belgian financial clearinghouse known as SWIFT. This controversies continued, and it grew into a book.
There was an argument raised that the first leak concerned a program that was of doubtful legality. And could you tell us what you found out about that?
Well, there's obviously a continuing debate about whether the NSA wiretapping program violated the law. the law in question is the Foreign Intelligence Surveillance Act, which says that that law itself is the exclusive means, has that provision, exclusive means by which the government can engage in surveillance in the United States. Now, the program arguably admittedly did not use the FISA Act for its operations. It went outside of the FISA Act.
But several presidents have taken the view that that act does not restrict their constitutional authority to protect the country. In fact, the president under whom it was signed, Jimmy Carter, his Attorney General, Griffin Bell, issued an opinion at the time saying that statute would not restrict the president from acting in the national security if he thought it necessary.
Right, that's the case, and that's why this debate continues. Of course, I think in the court of public opinion, the side that says that the wiretapping was illegal has seemed to prevail. The major media outlets are all behind that, and but it's become kind of conventional wisdom that the program was illegal. However, it wasn't illegal. The law itself, the FISA Act, probably was unconstitutional. But let's put that aside. Let's grant the New York Times for a moment its case that it was right to publish this story because it was exposing illegality by the Bush administration, and that they performed some sort of valuable public service in their view by bringing the story to light. Let's move forward 6 months.
What about the SWIFT system?
To the SWIFT case, where in the SWIFT case, the government, the CIA and the Treasury were monitoring al-Qaeda finances through this Belgian consortium, as I noted. They were doing so with warrants under a statute that was clear. There was no question of illegality. The Times' own ombudsman, the public editor, said that the program, the SWIFT monitoring program, was letter of the law legal. So why did the Times go ahead and publish the story?
What was the justification that was described by one of the reporters involved in publishing that story?
Well, he said he had gotten some legal opinions that the program might be illegal. He didn't quote any legal authorities to that effect. But he said beyond everything else, the story made for an interesting yarn. Now, one can't imagine a more trivial justification for publishing information that truly damaged national security. And the reason we can say that, point to the damage, is that this was a program that had, while it was in operation, led to the arrest of leading al-Qaeda or leading figures affiliated with al-Qaeda, like Hambali, the man who was the mastermind of the 2002 bombing in Bali that killed hundreds of people, or 100 people or more. So there were also a plot against the Brooklyn Bridge that by an al-Qaeda operative who was based in Chicago that was also broken up by this program. And I should add that the program, though legal here, was operating in secret, as I noted. And when it came to light, European public opinion or elite opinion turned against the program, and the European authorities who had been cooperating with the U.S. in this vital intelligence program engaged in a kind of paroxysm of anti-Americanism. They tried to close the program down, and did close it down for a period of time. And so the Times' story had real consequences for our security. We were deprived of a window into which we could peer into the way al-Qaeda was moving its money. And the September 11th Commission had singled out financial transactions as one of the areas where the U.S. had been particularly weak in understanding what our adversaries were up to. We had not been monitoring how al-Qaeda was moving its money. So this SWIFT program was an answer to that weakness. It was an attempt to fill the gap. And here it was compromised. And
because it made an interesting yarn.
It made an interesting yarn. And I mean, one can point, to very specific examples of the damage. I think you wrote a piece in the Wall Street Journal in which you noted that Faisal Shahzad, the man
the Times Square
bomber, had moved his money, or the money that was moved to him to enable him to carry out his plot, to buy explosives and so forth. That money came to him not by wire transactions, but by courier, in an attempt to evade surveillance. And so one can point to very specific examples of harm.
How's your book been received?